This is Michael Popok, Legal AF. Judges protect other judges, and all judges' eyes are trained on Donald Trump and his daily, hourly misconduct towards the court system, state and federal. Today, Judge Kaplan, a federal judge, Southern District of New York, who is presiding over all things E Jean Carroll, she being the editor who was sexually abused and defamed by Donald Trump, says a jury back in May in New York, and for which he had to pay substantial damages, has a second case against Donald Trump related to statements he made about her while he was president. And the judge there, Judge Kaplan, has decided for the second time that a jury needs to be protected from Donald Trump and making them anonymous, meaning once again, we'll have an anonymous jury for now the third time involving Donald Trump because of his violent rhetoric and attacks on all aspects of the criminal justice system. Third time, because in May, when the first case related to E Jean Carroll was tried, Judge Kaplan imposed an anonymous jury. And he cited at that time that Donald Trump back in May, God, it seems so long ago, seems like a more primitive time, that Donald Trump had a notorious history of attacking jurors, grand jurors, prosecutors, witnesses, staff personnel, judges, and the like. And he said, I'm going to have to protect this trial and the sanctity of this trial, and I'm going to make it an anonymous trial. In fact, the lawyers for Donald Trump at the time, it was Joe Tacopina, that's how long ago it was, Coloring Book Joe, as I like to call him, and Alina Habba, they didn't object. They were like, sure, anonymous jury sounds good to us. It is remarkable. It is probably one of the first times in New York court history, and I've been part of New York court history myself for 32 years, in which a non-criminal case, not involving organized crime or drug dealers where people could be knocked off, including jurors, used an anonymous jury. You don't do that in civil cases, but they did it for Donald Trump at the time. And think of all the things that have happened worse since May involving Donald Trump to today in October. His attacks on grand jurors, on jurors, death threats against Judge Chutkan, death threats against Judge Merchan, death threats against Fani Willis, the Fulton County District Attorney in Georgia, all because of Donald Trump. That's just in the last 5 months, 6 months since that trial. So is it any surprise that on the day that Donald Trump and his team, including Chris Kice, the lawyer, got gagged a second time by a judge to stop their attacks on courtroom personnel and on the justice system, Judge Kaplan decided in a 2-page order I have right here that the second E Jean Carroll case involving the defamation and punitive damage amount. This is only about damages. The judge already found liability. The judge already found that Donald Trump, back when he was president, defamed her. Now it's on to punitive damage amount without defense. I mean, there's an argument that they've raised about he has presidential immunity to have defamed E Jean Carroll, but no one's buying that. I don't think the Second Circuit is buying it, which is the appellate boss for Judge Kaplan. So the trial continues in January. So don't worry about, well, there's a criminal trial in March, and there's a criminal trial in May. What am I going to do in the first quarter? You're going to watch or you're going to hear about, at least here on the MeidasTouch Network, on Legal AF, about this civil case and how big of a check the jury is going to write to E Jean Carroll after they hear all of the evidence against Donald Trump. But that jury is going to be anonymous, meaning we're not going to know, the outside public is not going to know about who they are, if they're male or if they're female, what their backgrounds are, what their professions are, what their educational background is, where they live, or anything that people could piece together to allow the public and Donald Trump's doxing violent followers to know who these people are. No sketches of them, no photographs of them, nothing. And so, but the judge could have just said, look, there's no objection. I raised the issue back in October. On October 11th, I asked the parties to tell me what their position was on anonymous jury, understanding I already put an anonymous jury in place in May. And hearing no objection, I therefore make it anonymous. But that's not what the judge did. The judge pointed to things in the recent misconduct of Donald Trump to support the anonymity of this jury, to anonymize the jury. Here's what the judge said from just this afternoon. On October 11th, the court directed the parties to file any objections to trying this case before an anonymous jury. Neither objected, and the court received no objection. For the reasons stated in the court's decision ordering the use of an anonymous jury in the trial of a closely related second case, the court finds that if jurors' identities in the trial of this case were disclosed, there would be a strong likelihood of unwanted media attention to the jurors, influence attempts, and/or harassment or worse by supporters of Mr. Trump or by Mr. Trump himself. And this is where here's the stick, right? Here's the shiv by the judge. Indeed, in the very recent past, Mr. Trump has been fined twice for violating a gag order issued by a New York judge in response to comments made by Mr. Trump in relation to the judge's law clerk. In view of Mr. Trump's repeated public statements with respect to the plaintiff and court in this case, as well as in other cases against him, and the extensive media coverage that this case already has received and is likely to increase once trial is imminent or underway, the court finds that there is a strong reason to believe the jury requires the protections prescribed below. No less restrictive alternative has been suggested, and the presumption of access to juror names is overcome by the risks identified herein and in the court's previous decision. Meaning, even the participants, even Trump's lawyers, aren't going to know the names of the people at all prior to the trial, and probably at the trial until they're moving to select them. The court also said in a footnote at the bottom of page 2, examples of Mr. Trump's previous attacks on, quote, courts, judges, various law enforcement officials, and other public officials, and even individual jurors in other matters are detailed in the court's decision ordering the use of an anonymous jury in the trial of Carroll 2, the prior Carroll case in May that concluded in May. So here is the judge's ruling. The names and addresses and places of employment of prospective jurors on the panel, what we call the voir dire panel, which is Old French, as well as jurors who ultimately are selected for the petite jury, which is the jury that tries a case, shall not be revealed. Petite jurors shall be kept together during recesses, and the U.S. Marshals Service shall take the petite jurors to or provide them with lunch as a group throughout the pendency of the trial. So he just put the jury under U.S. Marshal protection where they can't, because let me just explain this. Normally, during breaks and lunch, jurors are free to leave and come back on time. They walk around with their juror badge even outside so people know they're a juror, so there's no accidental ex parte communication with a juror. We're taught as lawyers that if you accidentally or inadvertently get into an elevator and you look over and one of your jurors happens to be there, or any kind of juror, you should step out. You shouldn't even be there closed mouthed. If you can, you should step out of the elevator. If it's too late, you are certainly not to make any communication with any of the juror. And that's the way it works. But when they walk around looking for lunch in downtown New York, and there are very limited choices in downtown courthouse New York, I'll just tell you that. I struggle to find lunch down there all the time. But you'll find a sandwich shop, a salad place, maybe a bar for a quick sandwich without a drink. The jurors go there, but they're not going to be allowed in this trial. They're going to be chained together with a U.S. Marshal who takes them from place to place or brings them their lunch as a group. And then finally, at the beginning and end of each trial day, the jurors shall be transported together in groups from one or more undisclosed locations at which they assemble and return to their respective residences under U.S. Marshal protection. He just made them the wards of the U.S. Marshal Service. This is a civil case against the guy who used to be president of the United States. And if Donald Trump, as I said at the start of this hot take, doesn't think that all the judiciary, state and federal, isn't glaring at him and watching his every move and using what he does in one courthouse or courtroom in theirs, this has got to be the dozenth opinion that we've analyzed on Legal AF in which a judge like Judge Chutkan or Judge Merchan or Judge McAfee down in Georgia, who, by the way, also anonymized the jury that's going to be used with Donald Trump. That got very little fanfare. because he just said it's going to be anonymous. He didn't go into a whole, the jury needs protection from this menace to society, Donald Trump, including U.S. federal marshal protection. Okay? He's almost put them in a jury protection program. There's a reason that these judges mention all of Donald Trump's conduct in other courthouses. And Goron talks about what happens in Chutkin's. Chutkin's mentions what happened in Goron, and now everybody will mention what happened with Judge Kaplan. And right now, at the same time, in Trump world, you have these spinning plates that all relate to each other. At the very time that this judge found it necessary to anonymize the jury and put them under U.S. Marshal protection for their own protection, another judge, Judge Chutkin, reissued her gag order to stop violent rhetoric to be used against witnesses, prospective witnesses, prosecutors, their staff, their family, and lawyers and the like. At the same time that Donald Trump got a temporary stay of that at the D.C. Circuit Court level by 3 judges, all appointed by Democratic presidents, by the way, who are now going to look over the landscape and see Judge Kaplan and his taking what's called judicial notice of events outside of his courtroom. They'll be able to take judicial notice. I mean, technically, appellate courts are supposed to be working off a record that was developed at the trial level below, but they can take judicial notice of other events. And that's what Judge Kaplan just did. He said, it didn't happen to me, but I can take judicial notice of this fact that Donald Trump was gagged twice and violated a gag order. And it's been gagged again. I mean, if he really wanted to stick it to him, he said, you got gagged again. Except this came out probably an hour before. I'm trying to see a time on this. This came out maybe an hour before the second gag order, so it might have passed in the night between the 2 judges' orders in 2 systems. But they can take judicial notice of bad things that Donald Trump is doing in other courtrooms and other courthouses and use it in their own opinions. This is either something that Donald Trump, this concept, this logic, Donald Trump is either allergic to or he just doesn't care. Because nobody is thinking about this on the 4-level chessboard that is going on here between all the different jurisdictions. 7-level, if you think about all of his cases, that's going on here. There's no one lawyer. There's no one strategist, quarterback that's putting together all of his defenses. Because Donald Trump doesn't have lawyers at that sophistication level to assist him. He's got a 3-man shop here. This is like a 1-man band, right? With the banjo and the cymbals between the knees and making all the harmonica, making all the music. That's his law firm. He doesn't have a serious law firm defending him in any of these cases. Chris Kice used to be part of a large firm. I was a member of that firm. He left that firm to take Donald Trump as a client. He's in a 2-person office. Todd Blanche, in a huge firm, left that firm to take Donald Trump as a client. He's got 2 employees. Alina Habba has a 5-person office in New Jersey. Okay, the average large firm in America is 2,500 lawyers. None of them would touch Donald Trump with a 10-foot pole. Right, and now you're watching it. Right, and the judges are watching the misconduct and the failure to coordinate and come up with any coherent strategy at all. And now it's coming home to roost in orders like Judge Kaplan's that we just read in the E Jean Carroll case. On a day when Judge Chutkin's gag order was only temporarily stayed, subject to being evaluated by the D.C. Court of Appeals and likely upheld against Donald Trump in his actions down there, which will be cited in the Judge Engoron case when that gets to the Court of Appeals in New York, in the civil fraud case where Donald Trump was gagged again today, and then another order coming out effectively telling the world that Donald Trump is a menace from which jurors need to be protected and put in a juror protection program sponsored by the Federal Marshals. We'll continue to follow on hot takes just like this one on Legal AF, the leading podcast at the intersection of law, politics, and justice. One place, the MeidasTouch Network. Free subscribe. Help them get to 2 million. They're so close. And the larger that grassroots network gets, the more your voice is heard and resonates. Follow us on Legal AF every Wednesday and Saturday, 8 p.m. only on the MeidasTouch Network. and on audio platforms wherever you can get it. Help me with the ratings. I do these hot takes about every day, sometimes every hour. Give me a thumbs up. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.